Well, hello everybody, and welcome to the first of the lectures that I'm going to be delivering to you as part of your business law program. My name is Iain Sim, and I'm taking over from Jenny to take you in a different direction. I'm going to be talking to you over the course of the next 6 lectures about commercial legal topics. So we're going to start today by looking at the basics of the law of agency, and then I'm going to spend probably 1.5 lectures on the law of partnership starting next week, and then I'm going to look at company formation. We'll look at the principle of what we call separate legal personality, and then we'll look at company directors' duties, and probably, if we've got time, the company directors' disqualification legislation. Within this, there of course is a requirement for you to regularly open your textbook and do all of the additional reading that you need to do. The lectures are very much just going to give you the bare bones of the subject necessarily, so it's not possible to read out entire textbook chapters. So the onus is very much on you to do all of the reading around the various topics. And because time is tight in terms of contact teaching time, if we get towards the end of my participation in the programme, or my bit of the programme, and we don't have time to finish off company directors' disqualification, then I will be giving you that as some homework in preparation for the examination. So firstly, my apologies for delivering this first talk via a video lecture. As you can probably hear, my voice is not as it ought to be. I don't normally sound like this. I normally have quite a clear, loud voice, but at the moment I'm struggling to talk because of a sort of seasonal virus. So it's better that I don't try and come in to the university to shout loudly in a big lecture theatre, because quite simply my voice isn't going to hold out and you're probably not going to hear me very well at the back. So for this lecture only, I'll be delivering it via this video, and next week I'll be back in as normal for the Wednesday and the Thursday face-to-face lectures. So if you've got any questions about what I'm about to talk about in terms of the law of agency, then either you're welcome to save them up till next week if you want, or you can email them to me. My email address is Iain with 2 i's .sim with 1 m at strath.ac.uk. That's ian.sim@strath.ac.uk. 2 i's in the Iain and 1 m in the sim. Okay, so to kick off the commercial stuff, we're going to look at agency law, and I'm going to talk you through a very short lecture. It's only 11 slides, so this won't take terribly long. Agency, and as I talk through the slides, I'll call out the numbers as well, so you know which one I'm on. So if you just skip into slide number 2, agency is very much a relationship. It's a contractual relationship, and it's kind of like the relationship that you have with your mums and dads, or boyfriends and girlfriends, husbands and wives. You've got a parent-child relationship with your parents. You've got a husband and wife relationship, or a marriage relationship with your spouse. You have a boyfriend-girlfriend relationship with the person that you're going out with. And that is, in effect, all that agency describes. It is a type of relationship. And it's a relationship that you'll be very familiar with already. Quite a lot of students say, well, we've never heard of this relationship before in our lives. Well, in fact, you have heard of this relationship before in your life. So, for example, in the past, when you went to book a holiday, probably you'll have gone in to book your holiday with a travel agent. You know, you will have seen in the press in the last few weeks the collapse of Britain's oldest travel agent, Thomas Cook. Some of you probably had a holiday with Thomas Cook at some point in the past. And that's a really good example of an agency. You know, it's a travel agency. There are also, I'm sure you'll be aware, modelling agencies where agents try to get the models on their books work, in the same way that the agent at the travel agency trying to book a holiday on your behalf. And so there are different examples of agency that you will be familiar with, even though you might not necessarily have thought of it as legal agency. And actually, one other thing, for those of you who work part-time, insofar as you work for an employer, let's say Tesco or McDonald's or Sainsbury's or whatever it is that you do, then you are actually the agent of the employer. You are their agent, and we'll talk about that a little bit later on in the lecture. So agency simply describes a relationship, but it's not just any ordinary relationship. It is what we call a fiduciary relationship. And in fact, if you look at the definition on slide 2, I'll just read it out to you. If you look at the classic definition by Bosted and Reynolds, the definition of agency is a fiduciary relationship that exists between two persons, one of whom expressly or impliedly consents that the other should act on his behalf so as to affect his relations with third parties, and the other of whom similarly consents to act or so acts. The one on whose behalf the act or acts are to be done is called the principal. The one who is to act is called the agent. So you've heard actually a number of these terms before. I mean, you've already done contract law, so you'll know all about express or implied acceptance of a contract. And I know a lot of you are accountants, so you'll find that in law, quite a lot of similar concepts creep up time and time again. And so it actually means exactly the same thing as you learned in contract law when we talk about express and implied in the context of agency. So let's break this definition down a little bit into modern 2019 English. So the first thing is that it says it is a fiduciary relationship. Well, what does that mean? Well, I told you already that it is a relationship, in the same way that you've got a relationship with your mum and your dad, you've got a relationship with a boyfriend or a girlfriend. It describes a relationship, but this is a contractual relationship, and it's not just any old contractual relationship. It is a relationship of good faith. That's what fiduciary means. It means good faith. In other words, it means it's a relationship based on absolute honesty and absolute trust. So it's a relationship of honesty and trust and good faith. And it tells you that it's a relationship that's got to exist between two persons. It tells you that one of the persons has to expressly or impliedly consent that the other person is going to do something for him. And you've come across that before already in your studies with contract law. And on the other hand, you also learn that the other person also has to consent, either expressly or impliedly, to undertake the actions for the first person. And then you just have some ordinary legal jargon. The person who is doing the act is called the agent, and the person who is instructing the act is called the principal. But one really key thing is this. In order for it to be an agency relationship, the person who's doing the act, i.e. the agent, has to do something to affect the principal's relations with third parties. So if you think about your travel agent, and you walk into a travel agency and you ask, let's say, to go, I don't know, where students go nowadays on holiday. We'll call it Ibiza because I've heard of that. So you book your holiday to Ibiza. What's happened here is that you've become the principal, the travel agent is your agent, and you've instructed that agent to affect your relations with a third party, namely whatever the holiday package provider might be, whether it's Thomas Cook or Thompson's or First Choice or whatever it might be. So your relations with a third party have been affected. That's a perfect example of an agency relationship in practice. So how do you go about forming that relationship? Well, I told you just a few seconds ago that it is a contractual relationship. And you've just done contracts, so you'll know all about this. It's really easy. You could do it by an express appointment. So somebody says, will you do this expressly? And the other person says, yes, I will do it expressly. So you have kind of a basic offer and acceptance going on. And so you could have an express appointment. And obviously the classic way of doing it would be to have it written down, and probably it's the best way of doing it. If you learn nothing else from your legal course, always remember one thing: write everything down. The number of people that I have met in my life who may well have a contract, who may well be in the right, who may well not be in the wrong, but who can't prove that they're in the right, is incredible. So make sure, ideally, that you have this sort of stuff written down. So ideally, it would be something that is agreed expressly between the principal and the agent. And even better, it would be in writing. But you could, of course, do it orally, i.e. you could do it verbally if you wanted to. There's also the possibility of implied agency, and that normally comes by inference in exactly the same way that you can infer acceptance of an offer in some circumstances in contract law. So too you can infer an agency relationship in certain circumstances. So typically, for example, partners of a partnership, as we'll discover next week, will have inferred agency. And also, as I said earlier, typically you, as employees of whatever company you work for as a part-time job, will be the agents of your employers, and that will be inferred from your contracts of employment. In terms of how long the appointment will last for, if it's an express appointment, then it's highly likely that it will be written down in the contract. If, on the other hand, it is an implied appointment, then it will depend on the circumstances, and either it will end after a reasonable period of time or a change of circumstances. And so, for example, if you left your employment, then by definition, that's a change of circumstances because you no longer work for that employer, so therefore you no longer could have the agency relationship with that employer. So you've got express creation, you've also got implied creation. We also have this thing called agency by holding out. Agency by holding out describes a situation where you allow somebody to represent themselves as your agent. The English equivalent is what's called agency by estoppel, but in Scots law we call it agency by holding out. So you, as the principal, would in effect allow somebody else to represent to the world at large that he or she is your agent. Now, you might be wondering why I'm talking through a slide and not mentioning the interesting names at the sides of the points. Now, the reason that I'm not doing that is because personally I never liked it when I was a law student. I found it quite disruptive when the lecturer said blah blah blah, brackets, Smith versus Smith, close brackets. It was more interesting when the lecturer went into explain what happened in the cases. I'm not going to go into explain what happened in all the cases that I talk about, but by now I know you've been through a contract module, so therefore I know that you will have been told that it is necessary when you're presenting a legal argument to give what is called authority. And in Scots law, we have a huge amount of authority that comes from case law, i.e. Decisions of court cases, because we have a common law system. So you get a lot of court decisions that are really important. So you'll see that what I've done is I've actually put the case names at the side of every bullet point. And if you're wanting to get a great mark when you do my questions in the exam, you need not only to tell me what the actual principle is, you also have to tell me the case law that is the authority for that proposition. So when I told you that you could have agency by holding out, the authority for that proposition can be found in the Rama Corp case. Okay, so that's me on slide 3. We're going to skip forward now into slide 4. The next type of agency relationship formation is what we call agency by ratification. Now, this is not pure formation because the relationship of principal and agent actually has to already exist. So the principal has to be in existence when the various transactions that the agent was doing took place. Now you might be thinking, what on earth are you talking about? Well, let me explain. So far I've given you methods by which agency can be created, principal and agent, and you have an agency relationship created. With agency by ratification, the relationship already exists. However, what we're describing with ratification is a scenario where the agent has done something that the principal did not want him or her to do. Let me give you a very rudimentary example, right? You'll see also that the cases that I'm referring to are quite often from the 1800s, and there's a reason for that. That's because, of course, back in the 1800s, you didn't have these phone gadgets that you could phone up your principal and ask a question. So we had to develop a whole bunch of principles to deal with it. So it might be, for instance, that you send your agent to an auction and you say to the agent, I want you to go and buy me 10 cases of wine, let's say for argument's sake. And the agent comes back and says, do you know what, Iain, I bought you 12 cases of wine because the price was unbeatable and the seller is about to go out of business. So I didn't think that you'd want to lose out on getting an extra couple of cases of wine at this unbeatable price. Now, what I would be doing by agency by ratification is in effect approving the conduct of the individual, even though I didn't ask him to go and do it. So I'm in existence, I'm the principal. This gentleman has gone and done something on my behalf which I didn't ask him to do, or he's gone further than I asked him to go, and what I can then do is retrospectively approve that. And that is what is called ratification, and that is what creates or extends the relationship. And then we've got agency by necessity. The agency by necessity basically is what it is. It means that it was absolutely essential for an individual to do what they did on your behalf. This was written at a time when we had a gentleman called Mr. Bell, and Bell wrote the principles of the laws of Scotland, but he wrote that hundreds of years ago, and he's what we call an institutional writer. An institutional writer is basically someone who did a lot of good work and who's now dead for a long time, and they become an institutional writer. I once had a student refer to me in an essay as an institutional writer, and I wasn't sure whether to be flattered on the basis that it suggests I've done good work, or be offended on the basis that what they're suggesting is I look as if I've been dead for 300 years, but we'll leave that sticking to the wall. Agency by necessity is very simply what it means. The agent had to do something because they weren't able to basically get in touch with you to seek specific instructions. And that's much more limited in modern times because, of course, you've got much better connectivity right around the world. So it's difficult to see how that might apply in the modern era. And finally, we have this thing called agency by statute, where a piece of legislation creates the agency relationship. So if you skip forward into slide number 5, that would be great. So we now know how these relationships can come to be. The question then is, how far can they actually go? So in terms of express authority, the answer to the question is that usually, because it's written down, you'll usually find the answer to how far it goes also written down. And it tends to be, generally speaking, quite wide in its scope. Compare and contrast implied authority. That's the one where you have inferred agency by the nature of your appointment. And that will very much depend on the circumstances. And because your agency relationship has been inferred, the extent of your authority by definition is going to be much narrower than express authority. But usually the courts are quite willing to say that your implied authority will go as far as it has to do everything that is incidental to your express authority, or everything that is necessary in order to deliver on your express authority. So, for example, if I gave you a really sort of rudimentary example, so I agree with Aidan O'Donnell, the course coordinator, to come in and deliver 6 lectures on commercial law. Fine, okay. So I've been asked to come into JA325 once a week and the other building once a week to give you 1-hour talks on commercial law. But Aidan doesn't tell me that I can specifically plug my laptop into the university's IT kit. So the question then is, do I have the legal right, in the absence of the course coordinator saying in writing, you can plug your equipment into the university's IT equipment? Do I have the right to do it? The answer is almost certainly yes, because arguably that is something that is necessary in order for me to discharge my responsibility to deliver a lecture, and it's certainly incidental to me delivering a lecture. So that is the extent of express authority and implied authority, and quite often you will see these referred to together in your book as actual authority. Then when we move on to the other types of authority, the nasty one really is ostensible or apparent authority. That's where somebody has been holding themselves out to be your agent that we spoke about a little bit earlier on. With apparent authority or holding out, then the courts are very willing to extend authority as far as it has to go. So with the internal authority, if I can call it that, with the express authority, which is written down in the contract, or the implied authority, which is inferred from that contract, you might say that these are internal types of authority, because only the people who are party to that relationship will know what has been agreed, and therefore will know what can be inferred reasonably from it. But that is really unfair on innocent third parties who are on the outside, who don't know what the contract actually says for express authority, and they don't know what the contract actually says, and to give them any meaningful way of discerning what might be implied authority. And so courts don't like that. So what they do is they basically extend the idea of holding out, or what we call apparent authority or ostensible authority, as far as it has to go, to give the innocent third parties a fair and reasonable remedy. I hesitate to use the word equitable remedy, because we don't really have equity as such in Scots law, but in effect that's what the courts are trying to do. They're trying to be fair to innocent third parties. So there was a case in Scotland not that long ago where a couple went to a Virgin holiday store and they booked a honeymoon, and they were very excited to book the honeymoon because they got a substantial discount on the holiday. What they didn't know was that the individual who sold them the holiday at a substantially discounted rate did not have the express or implied authority to do so. And in fact, the only reason that she was doing it was in fact because she had been either disciplined or somehow had fallen out with somebody in her place of work. And so she was doing it in effect out of badness or revenge. And when they found out that what she had done, they wrote to the couple and they said, look, this is not our fault, we're very sorry, we're going to refund hundreds of pounds that you paid us, but you're not getting the holiday worth thousands of pounds, because clearly this individual didn't have the authority to do it. So the couple went and got a lawyer, which is always a smart move, and they went to Hamilton Sheriff Court and they litigated the point. And the sheriff agreed that in fact these individuals had been acting in good faith. The young couple had never met the lady that sold them the holiday. There was nothing to suggest when they went into the shop that she couldn't do what she was holding out that she could do, what she was apparently able to do. And there was no information in the shop that would suggest to them that she couldn't do it. And so therefore they had no actual knowledge of what had happened, and they had no grounds to have reasonable suspicions about what had happened. So therefore, they were acting in good faith, and the judge felt that would be very, very unfair on them if, having acted in good faith, they were punished for something that was ultimately an internal matter for the holiday company. And so the company was compelled to give them the holiday at the discounted price. And that answers a really important question. How far will apparent authority go? The answer is it goes as far as it has to, without cap, which has some massive implications for modern business. If you've got somebody working for you in the future, and let's face it, you're all going to be, future business leaders, or you're going to be future executives in big businesses, and you've got somebody working for you, and that individual says something or does something on the phone or on email or face-to-face that you didn't know about, then is it possible to argue that they were holding themselves out as your agent? Is it possible that they have apparent authority? The answer is yes, it's very possible that they've got apparent authority. And so long as the third party was acting in good faith, it is very likely that a court would enforce against your company or your firm to the value that they have to in order to give an equitable remedy, a remedy of fairness, whether it's £1,000 or £100,000. So that's a really big challenge in modern business. Okay, let's skip into slide number 7. What duties do agents owe their principals? Well, the first duty is from the case of Black versus Cornelius from 1879. You don't need to incidentally learn the years of the cases for your business law exam for my section. I will accept the actual case names as being good enough for a really, really good mark. When I was at undergraduate law school, some of my lecturers insisted that we learn the year of the cases, and in some cases they also wanted us to learn all the actual page numbers as well, which, as you can imagine, was a big exercise in memory recall, but you don't have to worry about that. So the first duty is that an agent must act in person. So if the principal hires, let's say Iain, or let's say Aidan hires Iain to come and do a lecture, well, Iain has to come and do the lecture. I am not allowed to delegate delivering this lecture until to somebody else, unless I have two exceptions. Number one, what we have is authorised delegation. Now, arguably, you could say that by doing it on video as opposed to doing it face to face, I've got some sort of, digital delegation. But that's okay, because Aidan O'Donnell has said, look, you're unwell, by all means do the lecture by video. So I've got approval from my principal to do this lecture this way. Quite a good example. On the other hand, could I get somebody else from the law school to come and do it? Well, yeah, I could if Aidan approved it, but could I argue an alternative, which is that you can have delegation if it is normal for that particular trade or business or industry? Well, it might be normal, for example, in the building trade to send builder B instead of builder A, or builder C instead of builder D, because that's normal in the building industry. But it wouldn't be necessarily normal in the academic industry for lecturer A to agree to deliver a lecture and then subcontract that to lecturer B without asking for approval. So that's the first rule. You've got to do the job personally unless you've got authorised delegation, or delegation is normal in your particular trade or industry. And there's a further caveat to it, which says that if you do delegate, then it has to be de minimis. That means it's got to be as minimal an amount of delegation as possible. So I'm going to be back talking to you face to face, lucky you, next Wednesday. So I'm only doing this one video lecture. The second duty is an agent must obey his or her principal's instructions. So you've got to do what your principal asks you to do. So I've been asked by Aidan to talk to you about agency, partnership, company directors, separate legal personality, director's disqualification, all the kind of commercial legal topics. I have not been asked to talk to you about Taylor Swift. I might, as an aside, talk to you intermittently about Taylor Swift, but that's not what I'm primarily there for. And so I've got a duty to Aidan as my principal to obey his instructions. The third thing is I've got to exercise reasonable skill and care. So that means that I've got to give you, in the case of a service, I've got to give you, reasonable skill and care. I've got to give you my due care and attention. I've got to make sure that the information that I'm giving you is reasonably up to date and accurate. If I'm selling you a product, I've got to make sure that I don't damage the product. It covers anything about the adequacy of a product or the adequacy of a service. You must exercise skill and care. And then you've got to account to your principal and keep accounts. Now, accounting to your principal and keeping accounts all comes from the one case called Tyler versus Logan. Accounting to your principal simply means that you've got to give your principal an explanation for what you have done. So that's what we mean by accounting to your principal. And keeping accounts is, as you can imagine, is actually keeping financial accounts if money has been changing hands. Okay, the next batch of duties you will find on slide number 8. You'll remember at the beginning of the talk I told you that the agency relationship is a fiduciary relationship. It is one of good faith. So in addition to these specific duties that we've just spoken about, there are also what we call fiduciary duties. Now, it's really worthwhile learning the fiduciary duties because once you get into company law in a few lectures' time, you'll discover that most of the director's duties that we're going to talk about are basically direct lifts from agency law. They are basically a replica of the agency fiduciary duties. So once you learn one batch, you can basically replicate them in partnership and in company law. You might have different cases, different statutory references, but the principles are absolutely identical. So the first one is you've got to act in good faith. It's a good faith relationship, so you must act in good faith. So for example, if you told a lie, that would not be good faith. If you disclose confidential information, then according to the Liverpool Friendly Society case, that is not good faith. If you make a secret profit from your agent, so for example, if your agent says spend 25,000, from your principal. So if your principal says spend £25,000 and you as the agent spend £20,000 and you just don't tell them about the secret £5,000 that you've pocketed to pay for your luxury cruise to the Caribbean, well, you have sadly made a secret profit and you have to give it back to the principal, and that came from the Boston deep sea fishing case. You're also not allowed to sell your own stuff to your principal or buy your principal's stuff without disclosure. And that is an old case called McPherson's Trustees versus Watt, all the way back from 1877. This covers the situation of an auction house where your principal might be selling some stuff, or he might have asked you to go and buy stuff for him. So you're not allowed to sell things that you've already got when they've asked you to go and buy something from somewhere else without telling them, and conversely you're not allowed to go and buy their stuff without telling them either. Okay, so that concludes the fiduciary duties. All that remains on that slide is to have a very quick discussion about what you can do if an agent doesn't fulfill his or her duties. Well, very simply, if an agent doesn't fulfill his or her duties, then you can terminate the agency relationship. You can basically cancel your contract with them. And in that scenario, the agent will not be entitled to any payment under the contract. And in addition, you might be able to sue your agent for damages. Every breach of contract in Scots law gives rise to a claim for damages, and you may also be able to cancel any contracts that the agent made with third parties on your behalf. So if you skip through into slide number 9, what happens if the agent does her job properly? Well, if an agent does her job properly, then she's got a right to get paid. She has an absolute right to remuneration, and that either will be written down expressly in the contract, and if it's not, then you do it on a merit basis, what we call the quantum merit basis. And then she's also got a right of relief against properly incurred losses. Let me give you an example of what I mean by a right of relief against properly incurred losses. There have been a whole bunch of cases in Scotland about principals who ask their agents to go and buy stocks and shares on the stock market for them. And then when they buy the shares, the principal refuses to pay for them, leaving the agent with no other option but to sell the shares back on the stock market. And as you'll know, the stock market can go up and the stock market can go down. And get this, when they come to sell the shares, the stock market has gone down and they sell the shares back at a loss. They've got a legal right to recover that loss against their principal. Into slide number 10. Third party rights. What happens when you transact with third parties? Well, there are a couple of scenarios. So, number one, if an agent transacts with authority as your agent for a named principal, in other words, the agent has identified you as the principal to the third party, then you as the principal and the third party become bound to the contract and the agent steps out of the contract. On the other hand, the agent will be personally liable on the contract if the principal is not a legal person. Now, you won't understand what I mean by the principal not being a legal person is, but I will explain that to you when we come on to look at corporate separate personality. So park that in your minds for the moment. An agent will be personally liable if the principal is not a legal person. And also the agent will be personally liable if they have gone beyond all authority. So you have gone beyond anything that could be ratified. And into slide 11 of 11. If an agent acts as an agent for an unnamed principal, then the contract between the third party and the principal is binding and the agent will not be bound so long as the agent at some point tells the third party the identity of the principal. If, on the other hand, the agent refuses to tell the third party the identity of the principal and tries to keep the principal's name a secret going forward, then in that scenario the agent will be personally liable. If the agent contracts as the principal, in other words, not on behalf of the principal, but in effect the agent is trying to be the principal, then in that case the principal can disclose the interest and bring an action against the third party, or indeed can sue the agent. So the decision ultimately is one that the principal has to take. So that is really everything that I want to tell you about the introduction or the basics of agency law. A very simple topic, 11 slides, and there is of course material in your textbook which you ought to read. I strongly encourage you to do so. There will be, as always, something in the exam on agency. I won't tell you what it will be, principally because I haven't written it yet, but there's always something about agency in your final exam in some form or other. So it's such an important basic commercial principle that we can't not examine it. So it's something that is very well worth doing the additional reading and learning thoroughly and studying thoroughly for the future. Okay. Once again, thanks very much indeed for your forbearance in the matter of my non-attendance in person. I trust you'll understand that it really is in everyone's best interest if I just do this by video today. I will, however, be fully recovered for next week. I will look forward to meeting you all then and taking forward our discussion on partnership law. I would, however, ask that you make sure that you watch this introductory lecture on agency before then. And I'll see you next week. Thank you.